Good afternoon, everybody. Thank you for your patience. I'm so sorry we had a little bit of technical difficulties getting started here. Welcome to the webinar. My name is Fuji Whittenburg, and the topic today is Work Visa Options for Students Life After OPT. Just to make sure you're in the right place. Again, my name is Fuji Whittenburg. I'm an attorney here at Wolfsdorf Rosenthal LP, and this is a webinar that I regularly conduct, and we'll be actually doing it probably every month until the CAP season. You know, we offer this as an informational tool for a lot of you students out there. Obviously, you should speak to your international student office, and this is general information. So I, have to quickly mention that this doesn't constitute direct legal advice. It's for information only, and obviously circumstances and situations vary. But I do hope that you find it useful, and I'll go through everything. If we have time at the end, I'll try and answer some of the questions that you type into this the system. I think there's a function here where you can type questions. If not, please feel free to ask the questions, and I can answer them after the webinar. And you're also free to email me as well. And if I can help, I definitely will try to do so. Okay, so let's just get started. Some recent updates I just wanted to let you guys know before we get started. I know everybody's excited to talk about the CAP coming up, but the paperless I-94 cards, it's actually been almost a year. They implemented it in May. For those of you who haven't traveled yet and experienced traveling without having that white I-94 card stapled into your passport, I know it's been confusing for some people, but it's a paperless system now. So instead of using the paper I-94 card, they are collecting travel information through the flight manifests, and you can access your I-94 entry through an electronic system. The website is written here, so make sure that you access your I-94 record. You have to print and keep it for your own records, and for those of you who are switching over to OPT and H-1B, it's especially important because that's the way that your employer is able to verify your employment. So that's a new development. There have been some small glitches here and there, but I think everything should be ironed out at this point, and it's hopefully going to streamline things a little bit more when you're coming in. Okay, and I'll quickly touch on CPT and OPT. Obviously, a lot of you know what these two are, and again, more than myself, I think talking to your international student office about any issues that you have in terms of timing, when to apply. Usually a lot of schools have their own workshops where they provide students with information about all of the details. Obviously, CPT is it allows work study and internships. That's done strictly through the school. They have to approve it, and it has to be part of an established curriculum related to your degree. But it also allows for on-campus employment 20 hours a week, which is great. OPT, optional practical training. This is what most of you, I believe, are on right now, or you will be on once you graduate, or that's what gives you the work authorization. You're still in F-1 student status, but you are given OPT work authorization for 1 year once you graduate. You do have to apply. It's not automatic. I get that question all the time. So you want to make sure that you talk to your school, because they can help you with the paperwork, but it's also based on the program end date, so that's something you need to make sure you speak with them for. And you do need to wait for the EAD card, the physical card, before you can start working. For those of you in the STEM degrees, if your degree is one of the STEM fields, science, technology, engineering, math, there is an option after your 1 year of OPT, you can actually extend for an additional 17 months, which is about 29 months total, without ever having applied for an actual work visa. So this is a great option. Obviously, it's limited to degrees only in those fields. There is a list of degree programs that are eligible, and I provide the website here, It's the ICE website, and the job must directly relate to the degree major, and your employer, in order to qualify, has to be registered with E-Verify. Every year more and more employers are registering with E-Verify. It used to be something that was, kind of burdensome or cumbersome, I think, for some, but it's definitely a lot more common now. And you do, again, have to apply for it. It's not an automatic extension. So for anybody with a degree outside of the STEM fields, there is no OPT extension. A little bit more about OPT. I wanted to add some more details about unemployment periods because, I think that's obviously a concern for a lot of people, and they've definitely, it used to be back in the day, they never even looked at unemployment. They just never reviewed it. It didn't matter. But then a few years ago, they did come out with a memo. So you want to be careful and watch out for 90 days if you're in your, in the 1 year of OPT. If you're in your STEM extension, it's 120 days of unemployment that you're allowed up to that amount. You just want to stay in close contact with your International Student Office. I think I'm going to say that over and over, so bear with me. But you do, there are ways to avoid it. I mean, you can volunteer. It has to be in your field, so it's not like you can be like, oh, I volunteered and, I helped, my mom at her office or something, and then be like, hey, Mom, sign this letter. You actually have to do, a real, go to an, do a real volunteer project, and again, in your field of study. Something else to note, and I think I have it in a couple of the next, or I haven't added it yet, but there, I get this question a lot, and entrepreneurs, I'll be talking about startups a little bit when we get to the H-1B section, but you can, start your own company in OPT. I mean, you have to be careful, and there's some guidelines that you need to check, but the problem then becomes, it has to be related obviously to your degree. You have to actually set up a company. I mean, it has to be like a real formal company name as a real entity, but you also have to be, kind of obviously doing something, and the problem then becomes what's next. So let's say you do it for a year. Unless your company really grows tremendously, it does become, an issue of what visa do you transfer over to next. But it's an option. So for those of you who are entrepreneurs or, business-minded people, it's something that you can do or you may be able to do. And there are some questions about, whether or not you need, I get the question also about investing into companies where you're not actually working for the company, but it would be more like a passive investment. Obviously, these are all very technical issues, very fact-oriented, so it's something that I'm happy to talk about with you, but they're very technical. But there are some options out there about that, so just my little side note. For OPT, don't forget to apply. Again, it's not an automatic benefit that you will receive. Your school's not going to, be like, oh, hey, here's your card, by the way. You actually have to apply for it. And there's a time frame within which you have to apply, and if you miss that window, the opportunity is gone. So 90 days, as early as 90 days prior to your program end date. Program end date, there were some issues before. That's not actually your graduation date. So that's something that you need to talk to your school about what those dates are, or up to 60 days after your program end date. So it's, I mean, it is around your graduation date, but something to look at. So 90 days prior, up to 60 days after. During that time, and again, you want to check with your school to check on the exact filing dates. Apply for it even if you plan on returning home after graduation, or even if you don't already have a job secured. It's something that you definitely want to take advantage of. It's, again, I say this every time, but it's the one time that you really get this kind of open market work authorization where you can work anywhere. The employer doesn't have to sponsor you. It's a no strings attached kind of a work authorization. I mean, it has to be related to your field, so it's not that, open, but it's a good opportunity for you to explore an employment relationship with an employer and maybe use it as a stepping stone to find that, for that work visa, or just to see if you are interested in staying and pursuing your career here, or if you want to return home. And that's really what it's designed to do. That's the whole point of the work authorization. Okay, so let's say you do your OPT, you're in it, you're on it right now, and you're finishing up. What are your options next? So right now, what is it, January 16th? As many of you know, April 1st, CAP season starts. That's what I like to call it, March Madness. I was told is not the friendliest way to call what it is we do in our office in the month of March. But the H-1B visa is the kind of broad visa category that a lot of you will fall under and qualify for. There are some requirements for the H-1B visa. The job must be one that requires at least a bachelor's degree in that field to perform a job. And that's something that, again, before we would say, oh, you have a degree, that job is professional, then you should qualify. Well, USCIS is really honed in on the language here about a particular degree in a particular field. So, a lot of times broad degrees, like let's say you have a history, I'll give you my own, my bachelor's degree was in history. So I don't know what kind of a job I would really qualify for if I were to look at the Department of Labor, the website and the various resources that they provide. But they're really looking at, what your degree is in, if it's in a specific specialty. Some examples of the standard, kind of occupations for H-1Bs, what they consider to be professional occupations: financial analyst, accountant, software engineer, things like that. The fields that are probably the most common that I, currently, have, or people contact me because of the way I think the world is shifting, with new media and social media and all of that. There are a lot of marketing positions, a lot of market research, a lot of, it's all kind of shifting towards business development, things that I think, require a degree, but maybe are a little bit newer to USCIS. But there's definitely the argument. Anyways, we'll get to that later. H-1Bs are employer specific. You can apply either part-time or full-time, which, again, I get that question a lot. Maybe you have two employers who are interested in hiring you for part-time employment, whether it's for financial reasons, or they only have enough work that would support part-time employment. So that's an option for some of you. You can have two. You can have concurrent H-1Bs for multiple employers. There is a 6-year maximum on the H-1B. Unless you're, in a certain stage of the green card process, you can extend beyond the 6 years. And then the H-1B is granted a 3-year increment, so it's not something you're applying for every year. You're not worried about the cap every year. It's at-will employment, so that's a little comforting, I think, for some employers to hear. Although there is, this kind of, there's an employment relationship that has to be there, that you're saying to USCIS, yes, I'm sponsoring this person for this job. It is at will. So if they need to, terminate for any reason at any point, they can, and you can also leave at any point as well. And there is something called H-1B portability, which comes in really handy, that a lot of the other visa categories are jealous of. You can transfer employers. So you can change employers while you're on H-1B, and you don't have to wait for the approval, which is really nice. You do have to file paperwork. It's not like a simple transfer. You have to file a new petition with immigration. But as long as you file it, you can start working with the new employer. Okay, without further ado, the H-1B quota, which is coming up again. It's based on the fiscal year. A lot of people wonder, why April 1st, why October 1st? It's because of the fiscal year, which starts in October, October 1. So for this upcoming year, it'll be October. The H-1B quota, it applies to private employers only. I can't stress that enough. It's really important for those of you who are interested or working for universities or others that are not CAP subject to take note of that. Usually we always get emails from university employees like, oh my gosh, freaking out. So it's private employers only. There are 65,000 per fiscal year, which is clearly, not enough right now. But there's a carve-out out of those 5,400 for Singapore and 1,400 for Chileans. In addition to the 65,000, there's an additional 20,000 for U.S. graduates with the master's or higher. So you have to, that's if you graduate with a master's or higher degree from a U.S. school. And if you don't graduate from your master's program by the time you need to apply, so let's say you want to apply this April, but you don't actually finish your master's program until, June 24th, picking a random date, you can apply and using your bachelor's degree under the regular cap. And usually you're here, it's either, we call it the regular cap, which is 65,000, and the master's cap, which is the 20,000. How early can you file an H-1B? The earliest date possible is April 1st. And so we put, March 31st, you FedEx it out, and it gets to USCIS on April 1st. That's the earliest date. So the cap, some timing issues. So for those of you who aren't aware, or you're probably babies, but before we used to call this season March Madness, which I was talking about earlier, before basically 2009. And there was a computer-generated lottery, the select petitions, that happened again last year, and a lottery was conducted. So I'm assuming this year the same will happen. As you can see, because of the economy, things were not going as well. Companies weren't hiring as much. They were hiring freezes and layoffs and things like that. So to give you context, the cap would open on April 1st, and during March Madness, it used to always be just that first week. If you didn't get it in that first week, the cap closed and you missed your opportunity. Well, during the recession, it would open on April 1st, and it would stay open. If you can see, the cap was reached December, so it stayed open from April to December. So it was like 8 months, 9 months. It was months and months where you had this large window of time to apply for H-1Bs, which, was really nice, obviously, but at the same time, it also meant that the economy, people weren't hiring. So that was really difficult for a lot of students who were graduating. And so then last year, the cap was reached on April 5th, and a lottery was conducted. And the lottery, it's a computer-generated lottery. They're selected randomly. They shouldn't be, and they don't look at, who the petitioner is or anything. At first, it's supposed to be just a totally random lottery, and they select the petitions, then they assign the case numbers, and then they send receipt notices, and everyone else who misses it, they actually just reject the petitions and send them back with the filing fees. So they don't cash the filing fees. They'll just return it, everything's still intact. Let me think, I was going to mention something else about the cap. I think I'll get to it a little bit later. But and again, I think this season is going to be the same, where it's a computer-generated lottery. So you just want to make sure that you're getting everything, the timing of it all right. Related to that is the cap gap extension. So it applies to all students who timely file the H-1B petition during the acceptance period. So if the earliest, the earliest you can file is April 1st. Timely would be, obviously while it's, duration of stay is still in effect. Basically, as long as you file the H-1B petition before your OPT expires, then your work authorization and your F-1 status are automatically extended. So, let's say you have your OPT until June 24th of this year, and you file on April 1st, your work authorization, even though it says it expires on your OPT card, it's actually extended through October 1st, which is when the H-1B would kind of, take effect. And you have to file it as a change of status, which is a very kind of a very specific thing on the forms that you guys wouldn't know, but if your attorneys would know. But you have to file it in that way. But if I have a lot of people right now whose OPT are expiring for some reason in February, so like next month. So for those people, as long as, let's say, their OPT expires February 15th, we can't file the CAP case on before they expire, so the earliest would be April 1st. So they can't work. They can continue to be here, so their F-1 status would be extended, but they wouldn't be able to work for that time until October 1st. So we're talking, it's like 6 months where they, again, are eligible to be here, but they're not eligible to work, which I don't know if that's really that great. But at least they'll be able to continue to be here. And it's extended until it's adjudicated, or, and this date needs to be updated, I'm looking at it now, but until basically the last, September 30th or right before October 1st. And if it's denied or rejected, let's say you file it April 1st, you're selected in the lottery, and you get a request for evidence, you respond, and USCIS has some issues with it, and it's denied, and you get the denial on August 15th, you have an additional 60 days from that date, because for those of you on F-1 OPT, there's a 60-day grace period. So that still applies even if you file. So here's a handy little map, I think, that would help kind of, I can say all of these things, but when you see the little chart, so let's say you graduate, for those of you who are still in school, let's say you're graduating this June. Yay, congratulations. And you have your OPT starting July 2014, this July, for 1 year. So that would carry you through next spring. Next spring on April 1st, you would file your H-1B, and then your OPT ends July of next year, and then October 1st of 2015, your H-1B starts. So if you're selected, you have cap-gap relief between July and October. You don't have to worry, because previously, before cap-gap, it was really a hard place for students to be in, because they'd have to leave and then come back if they didn't have enough time with their grace period, and they'd have to stop, or they'd have to stop working, and employers were, kind of upset, and it made things really difficult. So this is a nice way of letting you continue to work. And so that's cap-gap. So a basic overview of the process, the agencies involved. It's USCIS and the Department of Labor. So it's two agencies basically that we're dealing with. The Department of Labor steps are first. In the early part of the H-1B, we have to first verify the FEIN, which is the tax ID number, the Federal Employer Identification Number. That takes a few days. Just for those of you who are planning, if you are filing this year or interested or filing next year, there are some time constraints. And then once it's verified, then you do the LCA, which is the Labor Condition Application. You have to submit it online, and it takes 1 week to be certified. So right here, we've got about, probably like a week and a half where we have zero control over, timing. So, and that needs to be done first before we can file anything. So once we get the LCA certified, then we can, prepare everything and submit the application to USCIS. Again, assuming you're selected, assuming there's a lottery and then you're selected in the lottery, this is the application that they'll be looking at. There's a support letter kind of confirming the job details, the forms, the fees, the support docs, which are, your education documents showing you've been maintaining your status. There are some, there is the chance that you'll get an RFE, a request for evidence, where I think the biggest challenges, or I don't know, the most common types of RFEs, I would say, would be for, they want us to describe in more detail what the person is doing and to demonstrate that it's a specialty occupation. the degree is related to the occupation, that a degree in that field is actually needed, because a lot of jobs, they will try and argue that although some employers prefer or want to have somebody with like a bachelor's degree in business or marketing, it's not necessarily required. So particularly those fields like kind of sales and marketing, they like to say that somebody with 10 years of experience could also do that job, which in theory, yes, maybe, but again, to me it depends on what the needs of the employer are. If the employer has historically always hired somebody with a degree for that position, there are certain things that you can do to argue that it does require somebody with a degree. I've submitted work product before where somebody's actually doing market research. It sounds very vague, but when you're showing the kinds of technical research and reports that the person is generating, I think that tends to be a little bit more convincing to the officer. So sometimes you have to be a little bit creative in terms of how you're demonstrating what it is you're doing, and to really work with whoever it is that's helping you with this to really try and provide as much information as possible. What was I? And then for something else to bring up about requests for evidence, I kind of skipped over this, was vibe. And this kind of relates to the company. So another super common question I get, one is, which occupation should I choose? Give me, like, which one will get me approved the fastest, or which one's going to work, that kind of stuff. We have to be specific and, in terms of it should match what you're doing. But the second is Vibe. It's an instrument that, an online tool, I say instrument meaning a tool, that USCIS uses to check the viability of the company, where they look up the tax ID number and the address and make sure everything matches up. So for those of you who are always asking, well, what if it's a startup, or what if it's a small company? Obviously the larger companies, tend to probably have an easier time because they have the financial backing, they have the viability, they can cover overhead, they can pay your wage. Those are the issues that USCIS is most concerned about. And they, kind of, I think, not, incorrectly assume that, smaller companies can't support some of these more sophisticated positions, which is not true. But anyway, so they do check into things, and the system is called Vibe. So we'll get what we call a Vibe RFE, where the employer just has to make sure that all of their registry, if they're registered with the state and then with the IRS and those kinds of things, that everything's kind of lined up correctly. A quick overview of some of the other points I wanted to make. We talked about the 6-year maximum. The exception I write here, the AC-21, that's for, if you're at a certain stage in the green card process. For H-1Bs, you can extend them, and you only have to worry about the cap once. Once you're counted in, you're never subject to it again, unless, of course, you want to be. If you leave the U.S. for a year, you've had 6 years, you leave, and you want a new 6 years, then yes, you would be. There's a remainder option. So, I don't know. There's always a few instances where someone was in H-1B status, and then they went back to school to get a master's degree or an MBA. So they want to, and then once they finish, they can switch back to H-1B status, and you can use whatever time is left over. So I don't know if that's an option for interview, but it's worth exploring, and you wouldn't be subject to the cap again, unless you want, the whole new 6 years. And then quickly, H-1B issues for startup businesses, and this I added in here because it's, again, in today's economy, startups are all the rage. I'm here in Santa Monica. Their startups are calling it Silicon Beach here. Startups all over the place, and they're doing well. So people want to know once they're graduating if this is an option, whether they want to start their own or they just want to go work for a startup, which could be a great opportunity. But then, you have to weigh your career options versus, what's the best employer for the visa. So, and I get that. But the company has to show financial ability to pay your salary. USCIS is really concerned with that. One, that you're doing what you're saying that, or you're doing what we say you're doing in the petition. So, there's that whole professional occupation aspect of things, which at a startup sometimes, someone could argue that everyone does everything, which is true. I mean, if you're two people in the office, even though, let's say, you're the VP of Business Development, you're probably also, sometimes answering the phones, sometimes making your own copies, sometimes sending out your own FedEx packages. So that could actually take away from the professionalness of your occupation. Anyways, but then, and then the ability to pay, they want to make sure that the company, if it doesn't have, let's say it's a startup and you don't have these, tax returns showing, hundreds of thousands of dollars in sales or revenues, what I've been successful before in the past in doing is showing that what the investment is, showing that you have the backing, the financial backing to, cover overhead and cover salaries and, whatever's being paid to contractors and things like that. And then they also want to know that there's a place of business. So I know a lot of times things start out as a home office, or you can kind of work from anywhere. There are incubators, I know, all over the place where people kind of set up their businesses temporarily. USCIS is still kind of, old school about having an office, a work site, and an address. We do have, I've successfully filed applications for home offices. Don't get me wrong, but it should be an actual, separate designated space where business is being conducted. And, of course, that only applies to certain businesses. So service-oriented things or, again, like marketing, that kind of stuff where you're meeting with people outside of an office, yes. But if you're, opening up your own, if you're a dentist, having a home office is not, probably not appropriate, and it's inconvenient, and I don't know how you'd get all that equipment. So, it has to make sense. And another thing, a lot of times I'll include a copy of the business plan because a lot of what I just talked about, in terms of what are the projections, what is the backing, who are the people who are, if it's, if you have VC funding or whatever it is, all of that stuff should be in there. That will help demonstrate, again, the viability of the company, where it's headed, and so we'll include a business plan, including the financial projections. Having other employees, obviously is helpful. It's not required. Again, having more people there, like if you have an office manager, because then it seems, that person probably will handle the admin functions. And then, another issue would be the prevailing wage. So let's say, it's hard because usually, let's say you are going to be an executive at this startup. You're pretty high. If there are only like 3 people there, chances are you're high up in the position. So your salary, because of funding, you'll take a lower salary in order to get a stake in the company. So that's where there are conflicting interests there. And again, the specialty occupation of it, and you want to be able to argue that you're using your, education in this position that for the startup. Okay, so those are considerations, but it's something that I think is overcomable, and that's a word that I've made up. Employer obligations must pay. They must pay the prevailing wage. That's actually one of the first things I ask when someone calls about an H-1B. I obviously make sure I say, do you have a job offer? Yes. What do you do? There has to be a job offer in terms of occupation, and then how much are you paid? And then can you be paid? Are you being paid the prevailing wage? Which I give the link here. You can look it up. It's based on the occupation and also your city, where you're located. So, a software engineer in San Francisco is paid differently than a software engineer in, Houston, for instance. It just varies. One is, obviously higher than the other. One, it'll be lower depending on where you'll be working. And another obligation that the employer has is no benching. Benching is just kind of a term that's used just because it's a slow season at work. They can't withhold work and pay and say, oh, you know what, we don't have any work for you right now, so we're not going to pay you, and tell you to just kind of like stay at home for a month. But if you do take a voluntary leave of absence, let's say you want to go home and travel back to, South America, for instance, it's a long flight and you want to go for, a month, then that could be a leave of absence, and obviously maternity leave is also okay. The employer is also obligated upon termination. Let's say that they're either having, layoffs, or there's, there's cause or something, but they're terminating you. They have to offer the foreign national a reasonable cost of transportation home, and they have to notify USCIS and withdraw the LCA and the petition. So there are obligations. A lot of times people are like, oh, no, my employer is going to be nice about it. They're going to let me. They're not going to, notify USCIS or anything like that. Even though they may say that to you, I'm assuming they probably have an attorney on their side saying, oh, no, you need to notify. I don't know, but it is a requirement. And then offering the reasonable cost of transportation home, that means home. So you can't, say, oh, the Bahamas is on my way home, so can you just book me a ticket to, I did have somebody say, like, oh, do you mind, can they, send or book my flight to, it was somewhere in Europe, like on their way back to, I think somewhere in Asia, and, no, they just have to offer that, and if you say no, then that's no. But that's where the employer obligations are. Who is responsible for the fees? Another very common question. In my book, employers should pay all of the fees. And again, we're still talking about the H-1B. But if the foreign national pays any fees at all, you have to be paid at least the prevailing wage. You have to be paid more than the prevailing wage. So I'll give you an example that I always give. Let's say the prevailing wage for your occupation, you're an accountant, and the prevailing wage in San Diego is $60,000. And then you're like, oh, that's crazy, that's great. I'm also being paid $60,000. And I'm like, okay, great, you're being paid the prevailing wage. And so at that point, if you pay for any of the legal fees or the government filing fees, your salary will drop below the prevailing wage. Who will know? Somebody will know. I don't know. There are different ways that this could come up. I've actually been involved in Department of Labor audits where we have to, where the employee says, yeah, the employer made me pay, and they look at payroll records of the employer showing that they paid X amount. So anyways, that's an issue. But let's say the prevailing wage is $60,000 and you're being paid $70,000, which I hope is the case. But if you can pay for some of the fees, I think you can pay for the legal fees. The government filing fees, there's some conflicting guidance out there about this issue, but the fraud fee and the training fee must be paid by the employer no matter what. And I say no reimbursements here, meaning that you can't be like, okay, you guys pay the filing fees and I'll pay you, or you can deduct it from my paycheck or anything like that. That's an absolute. The employer has to pay those. The other government filing fees that may be paid by the foreign national or the employer are the premium processing fee if you want a quicker response, or the $325, just the standard government filing fee. You can pay that as long as you're being paid above the prevailing wage. Okay, so a lot of fees are written here. I don't know. I'll actually list them. So for the H-1B, there are 3 government filing fees. There's $325 $500, and then there's either $750 or $1,500, what we call the training fee or the acquia fee. So those are the 3 government filing fees. There's the optional premium processing fee, which is optional, but the USCIS will adjudicate your petition in 15 days, and then there's going to be, some legal fees. Audits and enforcement, there have been an increase in investigations and work site visits. They've hired, I think my figures should be maybe updated here, but I'm sure they've hired more at this point. But they've created the Fraud Detection and National Security arm where an agent can show up, ask to speak with you, your supervisor, and again, I've had this happen with clients where an agent comes and they make sure basically you're doing what we said they were doing. They say, oh, does so-and-so work here? Can I go talk to him? They talk to the person. They'll talk to the HR person. They'll ask to see payroll records. So that's why it's extremely important that you are being paid the prevailing wage, and for your own protection, just to make sure. I get stories all the time where people say that, oh, the employer said they'll just, they have a lawyer and they'll write whatever and we'll figure it out. Kind of, don't worry, it doesn't need to be paid. You need to try and be obviously as upfront as possible and make sure that you're being paid the correct wage and the proper records are being maintained because they do take it seriously. I think just in terms of, before I move on, in terms of the cap, a couple other things I wanted to mention, that in terms of, because I've gotten lots of questions recently, about when to file. Obviously, you want to file it on April 1st, so I would get started as soon as possible if you're filing now. And then another common question is, should I do regular processing or premium processing? That's kind of up to you. To decide, when some people want it for peace of mind because they just want to know as soon as possible, whether or not the petition has been selected and whether it's approved. So that's up to you. There's an H-4 visa for spouses and children of H-1B visa holders. It does not provide employment authorization, but they can go to school. So what happens when you reach 6 years? Is 6 years really 6 years? You can recapture time spent abroad. So let's say, during the 6 years, every summer you go home for, 6 weeks or something. Over the course of 6 years, that 6 weeks can add up. And we've had it where it's, we've been able to recapture, like a year of time. And it doesn't have to be home. It's just any time. So let's say you go to a wedding or you go to Mexico for a week. Again, all those little trips anywhere, if you go on business, like a business trip to China, all of those things really do add up. So you should keep track of that. There are a couple ways to extend beyond the 6 years. I'll talk about green cards towards the end of this presentation. But it's about being in 2 different stages of the green card process. So you want to make sure that you're there at some point, having your I-140, either pending for more than 1 year or approved, and so that you can extend in that way. My favorite, the top 10 myths about the H-1B visa. Hopefully, after what we just went through, you'll be able to answer these on your own. But here, no H-1B for small company or startup. You can have one. We just talked about that. I mean, it's going to be tough, and you want to make sure that you are able to, again, demonstrate the viability of the company and your position and the professionalness of it. But you can do it. There's no requirement to advertise. That's for the Perm-based green card. I think that's also something that's a point of confusion for people. There is a posting requirement where the LCA has to be posted at the worksite location, but it literally has to be, kind of hung up on the wall in 2 conspicuous locations. But they don't have to take out an ad. That's a green card requirement. You can change employers if cap is reached. So that's something, once the cap has been met and I don't know, next fall you start with your employer, you want to switch, you can. You don't get a new 6-year period every time you switch employers. It's 6 years total. This is the biggest one I get all the time. There's a 10-day grace period after layoff. That's not true. If you're laid off, status terminates immediately. So what I hope for everybody is that there's, the employer provides you some notice so that you are able to, find a job. And if you can find something while you're still employed, you can file a change of employer. You don't have to leave and then re-enter. So hopefully you'll have that. But there's no grace period. I get 10 days. People say, oh, you have a month grace period. Oh, I have this. There's no grace period. You can go to school part-time. So for those of you who are finishing and, you start on your H-1B and then you decide you want to maybe go to night school to get your master's or a law degree, something else, you can do that. You can't file, we talked about this previously, you cannot file under the master's cap before completing your degree. If you've finished, or let's say you're a doctoral student, you finished everything and, you finished your degree program, you've defended your thesis, you've done everything, you're just actually waiting literally to walk for graduation to get your degree, then you can apply under the higher category, but not, and you'd have to get a letter from the registrar saying, this is to confirm so-and-so has completed all degree requirements, and because of whatever is graduating, in June. So you would have to get a registrar's letter for that situation, but otherwise, generally speaking, you have to complete the degree or at least show that the requirements have all been fulfilled. Premium processing increases chances of approval. No, that's not true. That wouldn't be fair. And it's not. It's not true. I don't know in the lottery situation. I'll kind of off the record, I don't know, what it is, but I will say that my cap cases that were filed by premium processing were all selected. Again, that could have been a total fluke. I don't want anybody to hold me to that at all. I don't know, how or why or what, but that was just being selected. In terms of being approved, no. It's all about the contents of your petition. In fact, I do think they have, officers that are maybe even, more trained because they have to adjudicate petitions more quickly for premium processing. So I don't believe in making those kinds of, I don't know, guesses. Your crystal ball is as good as mine. But that's just something fun I noticed about last year. No one will check if you're actually working in the H-1B position. That's not true at all, which we talked about. So you never know. Work site visits happen. And it could come from a disgruntled coworker being like, oh, I know he's on a visa and really they have him like answering the phones or something. So you never know where it could come from. So you want to make sure that everything's on the up and up. Must have a U.S. degree to qualify. That's not true. You can have a foreign degree as long as it's evaluated by an evaluation agency and it's found to be the equivalent of a U.S. bachelor's degree or higher. So a lot of times people have like a 3-year degree. Depending on, it's not necessarily about the, that it's a 3-year versus 4-year. So what happens, the evaluation companies, and there are tons and tons of them, that we work with, everybody works with, they'll want to see the degree and your transcripts from your home country, and they have their own evaluation system. But so you can qualify with a degree from outside of the U.S. But to qualify under the master's or higher cap, it has to be a U.S. degree. Okay. So I've been getting lots of questions. I do appreciate it. I think there are too many for me to really read through now on the call, but I'll get to them later. I just wanted to say that. So thank you for your questions. Okay, so let's move past this. Let's say the cap has been met. Let's say, it's April 15th, you applied. Unfortunately, your petition was not selected. You get a call from your attorney, and they have the package and everything. So now what? What are your options? There are options. So that's the good news. H-1B for CAP-exempt organizations, which is what I was saying. So all what we've been talking about before was for private employers. They're subject to the CAP. These are CAP-exempt organizations, institutes of higher education, nonprofit organizations affiliated with institutes of higher education, nonprofit research organization. Please make note of that. It's not just a nonprofit. It's a nonprofit research organization, government research organization. They're very specific and will require you to provide documents, IRS-issued documents showing that they are CAP-exempt, or showing that they are one of these entities. So it's not something that's it either exists or it doesn't. I guess there's no room for argument here. And so let's say it's been met. Maybe you can look for a job, working at the university, or if you're interested in going down that road, that is an option. Let's say you do that and you want to switch back to private industry. You would be subject to the CAP at that time. So let's say you get a job with the university. This year you work for a couple of years, and then you get a job with, I don't know, Microsoft or something, and you want to switch to Microsoft. At that point, you would be subject to the CAP. You've never been counted. So when you're switching CAP exempt to CAP subject, you would have to. I just see a question. What about hospitals affiliated with a university? Yeah, so that would be, I'm pretty sure, but I mean, I have to double check. But yeah, the hospitals affiliated with universities are usually CAP exempt. Other options are the free trade agreement visas, and they're kind of similar to the H-1B visa, which depend on the degree and being the job being a professional occupation. There are H-1B ones for Chileans and Singaporeans, and they're always pretty much available. I've never seen it run out. And they're very quick and easy. I just did a Singaporean H-1B one where you put it together and they apply directly at the consulate. They make a visa appointment and apply there. There's no internal filing through USCIS. You have to do the LCA, but there's no filing. TN, NAFTA visas for Canadians and Mexicans. So if you are a Canadian or Mexican national, you can apply for the TN. And there's no, and same with the H-1B one, there's no CAP. So you don't have to worry about any sort of timing issues. You can apply at any time. Canadians can apply at the point of entry. So if you're driving across at the land border, if you're flying in at pre-flight inspection, you actually submit your TN application right there on the spot. They adjudicate it, which is kind of handy and nice. But at the same time, it totally depends on who the officer is that's looking at your application. Mexicans can apply. They apply directly for the visa at the embassy in Mexico. So still a little bit easier because you don't have. There's no internal filing through USCIS. You actually put the application together. They book the visa appointment, and now the new procedure is to go do fingerprinting like a day or two ahead of time. You go do that really quickly, then you go to the appointment and you apply right there at the consulate, kind of like how you applied for your F-1 visas. It's the same type of visa interview, but obviously about the job instead. And similar in the same vein are E3 visas for Australians. Australia has its own visa category of E3s for professional occupations. E3s are in 2-year increments and have an LCA. The TN does not have an LCA. The TN is just basically a job offer letter and supporting documents. The E3 is a job offer and the LCA, so you do have to be paid the prevailing wage according to the Department of Labor for the E3 as well. Some other options. The J1, not an option really, so I'm going to go through this pretty quickly. If you've earned a degree, and I'm assuming since you're, if you're listening, unless you're listening from abroad right now, if you've earned a degree in the U.S. And are here right now, the J1 is not generally is not going to be an option for you unless you return home, but it's a trainee visa. Some of you may have had one already for trainees and interns, and as you can see, the requirements is to have a degree from abroad or work experience abroad. So, and I only include this because some people, you know, had a U.S. degree, you know, and then moved abroad for a long time. So there's a J1. There's also an H3 trainee. Training in the H3 application, you would have to show that the training program is not available in your home country and that it would benefit your career abroad. So basically that, you know, you want to work with, like let's say you're a graphic design artist. You want to train with this apparel company here in the U.S., and and they have a set training program where they have interns kind of training under the designer or whatever it is. So you would do that, and the argument would be obviously that you know, working as a graphic designer at this apparel company in Los Angeles, you know, would be this huge opportunity. And you know, kind of have to describe that, and that you would take the skills and tools that you're learning in this training program home. And it would benefit your career abroad. And that's mostly, again, these are all for training purposes, which a lot of entry-level positions nowadays are kind of like internships and trainings. Some other options for the entrepreneurs that are listening, there's an L1 visa. There's L1A for multinational executives and managers, and L1Bs for specialized knowledge. You know, basically, I mean, the main requirements are you have to demonstrate that you have worked for 1 year abroad at the parent company or parent affiliate subsidiary as an executive manager, and that you're coming to the U.S. to fill an executive managerial or specialized knowledge position. So it's really based on, so there has to be a company abroad and a company in the U.S. Where you will work or can show that you've worked for the company at least for 1 year. And the key here is 1 year in the immediately preceding 3 years. So for those of you who are here on school, you're like, well, this is not going to apply to me. Why are you saying this? Well, you never know. I mean, there may be an opportunity, for example, to work for, let's see, I don't know. Okay, I'm trying to think of a global company. I'm just going to say like Nike, for example. They want you to go work in their offices in Brussels for a year, or they're like, you know what, we don't have a position here in our LA office or in our New York office or Seattle, wherever they're based, but we do have this position, again, you know, in Brussels or in Singapore. Are you interested? So you could go and take that position, and then maybe if things are going well, at some point you could be transferred back to the U.S. This would be the correct visa category to do that under. And then the one thing to take note of is you have to show, this is usually for larger companies, but also we've used it for smaller companies where somebody, you know, you worked for a company in your home country. It doesn't have to be as large as Nike, but it's a you know, kind of strong, viable company, and they want to send you to the U.S. or have you set up the new office, which is for the entrepreneurs. This is a great option, and it's a short-term option because they'll only give it to you in 1 year increments. So let's say you had worked for this company, or it's a family company, and you worked for the company, or it was your company, it doesn't matter, and you want to, you know, set up the new office here in the U.S., you have to show, again, that you worked for the company for 1 year and the immediately preceding 3 years, and that they're sending you here to set up the new office, and it's only going to be good for 1 year. And at the end of that 1 year, you have to show that the business has grown, revenues, you've hired a couple of people, or they're not going to approve it. They're going to deny your new office extension. But it's it's kind of a nice option. Otherwise, just generally, the L1A is good for a total of 7 years. L1B, which is a specialized knowledge visa, is 5 years. I skim over specialized knowledge because they're really notoriously tough on L1Bs, but it's definitely an option for those who are not executives or managers. The L1B is for specialized knowledge, so you have been working with the company's proprietary software, and someone can't learn what you know in 6 months. That's kind of the litmus test for whether or not it's specialized knowledge, is that someone else can't learn it in 6 months. And that's why they, you have that knowledge. I always use the formula for Coca-Cola. That's just knowing it. But if you're the actual person who, puts it together, then, or who, mixes everything, then you have that. You have a stronger argument. Spouses and children receive L2 visas. And the good part about the L visa is that spouses may also apply for a work permit. They get a card that looks just like your OPT card. It's employment authorization. It's unrestricted, so it's not tied, to a particular field. They can work, they don't, or not work. It doesn't matter. And the L visa, I always mention, it's a good basis for the EB-13 green card, because there's a green card for exactly this, for intercompany managers and executives. So, somewhere down the line during that 7 years, it could transfer over. It is tied to the employer, so the employer actually has to sponsor that. Another option for the entrepreneurs and business-minded listeners is the E1, E2 visa, treaty trade, and treaty investor visas. You have to check to make sure that first and foremost, that's the first thing if somebody asks about this, I ask, what kind of passports do you have? Some people have several nationalities, but you have to have a treaty between the U.S. and the treaty country. There's a treaty country list at www.travel.state.gov where you can check to make sure. And if your country doesn't have a treaty with the U.S., and there are definitely plenty that don't, then you're not eligible for this visa category. But if you are, it's a good option. You can, and at least half of the company that you're setting up or that you're buying has to be owned by the treaty country national. And you can start up a company or you can buy a company. So that's where that's good. If you're, either way, you do have to show us that, that you're part, at least 50% owner, or at least 50% is owned by someone from your treaty country. The treaty trader visa, import-export. So at least half of the trade must be between the treaty country and the U.S. So that's really good for, if you're manufacturing something in your home country and you want to import it into the U.S. Or if something's being made here in the U.S. and you want to export it, to your home country, something like that. That's a very kind of simplified version of what that would be. The E2 investor visa, which is what probably a little bit more common, is where you just kind of either buy a Quiznos and you want to just, that's you're investing into that business and that's what you're going to do, or you want to set up a restaurant. That's the easy way for me to show it. You get a commercial lease, you make a substantial investment. That's a requirement. They don't define substantial, but it's going to be in the 6 figures, and they want to see that it's at risk, meaning that it's not money sitting in a bank account. It's money that's been spent. So when I use the restaurant example, that you've bought all the special stoves and ovens and the pots and pans and all of those things. I think I've run out of time and I've gone over. So if anybody needs to leave, feel free to, or I'm getting close to that. The E2, just the money in terms of the investment, you have to show where the money has come from. So there, if it's a gift, we have to say where it's from. We just want to show that it's from a lawful source. So that's something I'll say. I'm going to kind of go more quickly through the rest of this stuff. But again, I won't be offended if you have to leave, and you can email me your questions. Spouses, just like the L, also get dependent visas and work authorization. For those of you listening who are in the kind of, let's say you had a successful career or experienced some success abroad, and then you came to the U.S. to go to school. The O1 could be an option. It's for aliens of extraordinary ability. It's broken down into two broad categories, science, education, business, athletics, and then O1B, arts, motion picture, TV. So I've kind of listed things, kind of the categories here. And a lot of people fall under these categories as well. If you're in the, let's say you're perhaps a graphic designer or an art director, got that kind of a thing. O2 visas, O3. The O1 visa standards are, they're quite high, actually, so that's why I kind of also want to skip through this. I just want you to know it is an option, but it's for people who have kind of risen to the top of their field, and they've, had some success, achievements, and I'll show you here some of the types of evidence are, it's going to be press or awards or nominations, invitations to present at conferences, those kinds of things. Quickly, some tips. This is just from me personally to you. I don't know, but it seems like social networking sites are, really valuable. Your school career services obviously is going to be very valuable. It's about connecting. I think placement agencies maybe, local embassies and consulates. Sometimes, people who have, will go to their local consulate and say, how can I help some people who, or offer jobs to people from my country. Maybe that's where they could post. I think it's important to point out that, that you have an international perspective, and it's a global economy, and it truly is. So I do think that that's a good argument, kind of to make. And cultural diversity is very important in the workforce now, and a lot of companies like to see that. And so those are just some small, tiny tips from me to you. I'm going to quickly go through green cards, and then we'll finish the webinar. So this whole the rest of the slideshow is about green card options. There are three ways broadly that you can get a green card. There's the green card lottery, which is now closed. There's green card through family, and there's green card through employment. So there is a green card lottery. It's closed actually right now, but it opens October to November every year. 50,000 green cards that are given away. Also, like the E2, this is one of those where you have to be eligible to participate. Not everyone is eligible. And if you did apply, by the way, it's written here, so it's closed, but you'll be notified in early May. You can check the website to see if you've been selected. It's based on country of birth. And so, I've listed here the countries that are not eligible. And it's based on, so it's called a diversity visa, so it's based on the population. So if they find that there's a high population of these, these foreign nationals in the U.S., that's why they take them off. And so countries are added back on and off all the time. A trick is you can cross-charge to your spouse's country of birth if anybody's, if you're married. So let's say you're Canadian, but your, spouse is from, I don't know, New Zealand, then you can apply. Okay, the second broad category, family-based. So it's an immediate relative of a U.S. citizen, spouse, parent, minor children of U.S. citizens. You get immediate benefits pretty much within about 2 to 3 months. You get work and travel authorization. So if you are, again, a lot of you I know are in school, so you're probably not married, but life happens, and if it does happen, that's an option for you. It would be if you're married for less than 2 years, it's a conditional green card. Another question I get asked all the time is, I have a child, I came here as a student, and they have a child here who's like 1. Can my baby sponsor me, or is there anything I get? Well, maybe in 20 years, once your child turns 21, then they can sponsor you. Obviously here in red, there's the repeal of DOMA in June of last year, so same-sex couples are now eligible for immediate benefits. So I filed a bunch of cases already, which is a huge change in the laws, and it's an option that was never there for a lot of people, but it is now. So something to consider. Some other family-based categories, I've listed them here. You basically have to check the visa bulletin. It's updated every month, so this changes every month, travel.state.gov. But as you can see, it just totally depends on the category, and it changes. But there are lots of long backlogs, like brothers and sisters of U.S. citizens. There's a 12-year backlog. That's pretty consistent. But again, it is an option. So you can go ahead and put the application in earlier. There are employment-based immigrant visas, so we call them EB1 through EB5. EB1 is first preference all the way down. This is the aliens of extraordinary ability, kind of similar to the O1 I was talking about earlier. EB1-2, outstanding researchers and professors, and then EB1-3 is the executives and managers, which is similar to the L visa I was talking about. There's a higher standard for all of these three, but they also have faster processing and wait times. There's rarely ever a backlog or anything like that. So that's why, if these are options, they would be good down the line once you're, maybe established in your career. And then EB2 and EB3 are perhaps the most common categories where most people fall under, second preference and third, and EB2 quicker than EB3. EB3 has the longest wait times. Under EB2, you'll find there's something called SCEDE Group 2, aliens of exceptional ability, and then the NIW National Interest Waiver, which if you can show that you're working in a field which is in the national interest of the United States, then you qualify there. And EB3 is for professionals with a bachelor's degree or equivalent, so that's probably the broadest category. The Perm-based green card process is probably, again, the most common. So it would be you're in F-1 status, and you do your OPT, then you do your H-1B, probably around your third or fourth year in H-1B status. We would start the Perm-based green card process, and this is where the first step is to do the labor certification, where the employer has to basically advertise for your job and conduct good faith recruitment efforts, show there's no qualified U.S. workers. And then the second step is to file the I-140, and the third step is the I-485. The reason why the third step is in red is where, when I showed you the visa bulletin before, this is where, unless your priority date is current, you can't file step 3. So that's where it makes a difference which category your Perm falls under. So that's where when you hear, has the person filed their adjustment? No, this is where a lot of people get stuck when you hear they've been waiting years and years. Here's a snapshot of what the visa bulletin looks like. So on the left-hand side, employment base is first, second, third, down to fourth. And then China, India, Mexico, Philippines, because of the high volume and the number of cases that are pending, they have different processing times than all other countries. And you'll see where there's the letter C written. C means current. So as you can see, EB1 for everybody is current. EB2 for everybody except China and India is current. And then the rest, you can see the time, the years. China has had some interesting movement lately. I'm sure for anybody who's born in China, you've heard of it or heard about it. Where if you look, the EB3 category is supposed to be the slowest, but it's actually quicker than the EB2 category. So anyways, It changes every month, and it's just based on the number of people who apply. So I think what happened was so many people from China, and people asking why that happens, so many people filed under the EB2 category that there was a backlog there, and so people from China stopped filing in the EB3 category, so now they're all caught up there. That's how that works. It's just all about volume of cases filed and pending and what they're able to get through, so it shifts based on that. So anyways, you can always check it. Again, travel.state.gov. I've said that website a million times. You can check it yourself. It's updated every month, and that's where you can kind of follow to see what's going on. Deciding between EB2 and EB3, that's not really up to you, unfortunately. It's not based on you. It's based on the actual minimum requirements for the job. So that's something that people ask about all the time, or I think it's just a misconception. Obviously, you have to qualify for what the minimum requirements are, but unless the employer says that you need to have a master's plus 2 years of experience, if they say, oh, no, you only need a bachelor's, then that's what you have to go with. Tricks that don't work, tailoring to your experience or education. There are lots of audits by the Department of Labor. They catch on. You can't place foreign language requirements arbitrarily. Again, if you're working for a translation company and you actually, like, translation and foreign language is actually a part of your job, just because you have a lot of, French-speaking, clients, or, you do a lot of business with China, you can't necessarily throw in a foreign language requirement. Usually when to start, I would say around the 4th or 5th year. Some other options that I'll just touch on, EB4 is religious worker, green card, immigrant visas or green cards. EB5 is I'm sure you've heard of it, $1 million investment, or the $500,000 investment. You can either do the $1 million one or the regional programs, which it's a pre-approved program. It's a pooled investment, so it's a passive investment. So if you want to, as an entrepreneur, be the one making all the decisions, you would want to do you would want to do the $1 million investment. Okay, so I rushed through that towards the very end. We made it. Yay. Thank you for listening. I am more than happy, again, to answer any of your questions. I have a lot that you have typed up here, so I really do appreciate the engagement. Honestly, thank you for listening. I hope you found this informative. I think above all, I just want you guys to have the information. Again, whether you contact me or anybody else, it's important to know all of this. Follow-up questions, email me, like us on Facebook, follow us on Twitter. You can sign up for our newsletters if you would like. I'll be conducting this webinar. You can check the schedule, I think, every month through April, and possibly even May, depending on how things go. So if you would like, you can listen to it again, or tell your friends. And I wish you good luck, and thanks again for listening.